This is Israeli Technology Founders Speak, a podcast of conversations with successful Israeli high-tech and biotech entrepreneurs. Hosted by me, Barak Hullman. Eviatar Aron is a patent attorney in the US and Israel who specializes in high-tech, software, electrical and mechanical engineering in other areas. I sat down with Eviatar in the offices of JMB Davis Ben-David in Jerusalem to discuss what he has learned from helping clients to get patents over the past 10 years. In this episode, we discuss what to do before getting a patent, how to avoid costly mistakes, the benefits of getting a patent for your business, tips for startup founders, and much more. This podcast is a creation of JMB Davis Ben-David, an intellectual property law firm serving clients around the world. You have great innovations. We keep them safe. It's not enough to just have a great startup idea or innovation. If you don't legally protect your innovations, products, and brand, anyone can claim them as their own. We keep your great innovations secure. Learn more by going to jmbdavis.com. That's jmbdavis.com. I'm sitting here in the offices of JMB Davis Ben-David in Jerusalem with Eviatar Aron. What role do you play here in the firm?
I'm a U.S. and Israel licensed patent attorney. I'm also a registered attorney in the state of Florida in the United States, but I mostly function as a patent attorney, mainly in the field of high-tech, software, hardware, medical devices, innovations, some mechanical, a little bit of medical devices.
Mm-hmm.
Anything that you can think of that you can do with a computer, applications.
And how long have you been doing it?
For about 10 years.
The whole time in Israel or also in the States?
I graduated from law school, and in 2012 came back to Israel, did my internship here at a local firm, and then got my license here in Israel, and I've been working at it ever since.
So what are some of the challenges when it comes to IP that high-tech companies that are trying to patent software, what are some of the challenges that they have?
There are a few. The first one is probably market saturation. Israel is, and the rest of the world, software is a big thing. There's a lot of inventions, a lot of innovation, and technology is very rapidly advancing, which makes it very difficult for new startup companies sometimes to figure out how they can get a foot in the market. What can they create that isn't out there already, or how they can improve something in a way that is innovative enough and inventive enough to make it patentable. Because the patent is something that allows them to prevent others from infringing on their technology and copying them, and then preventing them from gaining a foothold in the market.
Mm-hmm.
Another issue is that software in a lot of places isn't in and of itself patentable. You need to have some kind of technical effect into the real world that you can latch onto by using the software.
So, for example, the software that runs an iPhone.
So, for example, the software that runs an iPhone, it has to get an input of some kind, do some magic in the box that is the software.
A physical device.
In the physical device, preferably. And then an output. Let's say it displays something on the screen. It moves something. It has some technical effect or some realistic result that we can, to a certain degree probably, that we can interact with.
So have you come across companies that just have software without the hardware component?
We're going to have to try and find some way to integrate some form of hardware. Even though nowadays you can argue that the processor and the input of a device and its display, let's say its screen, its speakers, maybe some other device that's hooked up to it, is part of that chain of an integration of software into hardware that will allow them to make it patentable. But if they're just trying to get that algorithm or operation patentable, they're not going to be able to patent that in and of itself.
Have you come across people that had software like that?
Yes, especially because this is something that has changed with the law over time. Like in the United States, there's been a progression of change where software has become less and less patentable. In places like Europe where it's completely not patentable in and of itself. So a lot of people will try, and that's where their bread and butter is software.
Right.
Because they're programmers, they're software engineers. But unfortunately, when they come to you with an invention, you kind of have to tell them, okay, this is what you have. This is what you may need to further improve and get it to a point that it's patentable. It doesn't mean it's not new. It doesn't mean it's not inventive.
Right.
It doesn't mean you might not get an advantage over someone else or have a market for it. There's maybe a need for it, but as far as IP protection, you're kind of in problematic waters.
So what advice do you give to them?
Usually I will tell them, okay, what can we do? We'll look together usually at what can we do to make this patentable? What are you doing here that you yourself are not, maybe it's obvious to you because you do this on a day-to-day. So you're like, this is just the software. This is what's new. But what else can we add on to it here that will make it patentable? Meaning we're going to probably need to discuss how it integrates with the processor in a device, where it's located. Is this a multi-device system? Let's say it's a smartphone connecting to a cloud, or is it just, let's say, your smartphone? And where is the software running? How is it getting its data that's being processed by this device or the processor? And then what is the final step of what's the output? What are you presenting? What are you doing with this information? Because storing data is, for example, not something that is not patentable.
Storing data, you said?
Data storage is not patentable.
So what would you do in the case if somebody comes to you, they have, for example, an app or just some SaaS business with no hardware attached to it? Do you say to them it's just not patentable, or is there some advice you give to them?
Yes. Unfortunately, that's a situation where we may have to have that difficult conversation of this is not patentable. Yeah. And, there are many, many applications out there that aren't patented. And sometimes with software, one thing you can rely on is what is called being the black box, being a trade secret. Nobody really knows what you're doing behind the veil of what the display screen is showing you. You have a program, it's getting some input from you, it's asking you for information, your commands that you're putting into, let's say, the touch screen of your iPhone. The box is doing some kind of voodoo, some kind of magic.
Right.
You don't really know what's going on back there, and it's giving you back an output based on what you put in. In that situation, you can protect yourself by the fact that you're not showing anybody what you're doing behind the veil, what you're doing behind the screen. And then, if somebody really wants to figure it out, they'd have to reverse engineer it or somehow get at your code.
Right.
Now, depending on how lucrative it is to them, they might do that. But you might still be able to use that trade secret in that time that it takes them to reverse engineer your invention to get that footing in the market and get a heads up.
Right. Establish yourself.
Yeah.
We talked about software that's not patentable, and what you could do is, in a sense, like in a magic show. You watch something happen, it's right there in front of your face, but you can't figure out how they did it. And as long as they can keep it that way, then it's safe. But it doesn't provide any legal protection like a patent would.
No, it does not, but it still can give you some kind of protection.
Have you seen companies that still want to patent, so they create some type of hardware that they didn't really need, but just in order to get the patent on the software? Is that not important?
Again, today, because most software requires some kind of hardware to actually do something.
But you said data storage, for example, is not patentable. Right. Even though that does take hardware because you're storing the data on hardware.
Correct, but because then you're not really doing anything. There's no real output with this data. Basically, when you look at software and high tech, you have to have 3 stages. You have to have that input, that processing, analysis, which can include also some form of data storage, but then some kind of output. Once you have that kind of chain, then you're more likely to get a patent. But usually that the conversation is more like, okay, so where are you running your program? It's not so much, do we have to invent any kind of hardware for it? It's what is the hardware you're using? Because again, like I said, software engineers and people who usually work in the software world, or even in AI, which is a very hot topic now, they're thinking about the software. They're thinking about the algorithms. They're thinking about what they're actually doing. To them, the step of, well, I have a computer. I have a processor. I have these devices that I'm using to achieve the software. They don't think about those things. And those are the parts that actually, to make it patentable, you have to include them. They may seem generic or commonsensical, but when it comes to the patent, those are the things that you kind of require sometimes to push it over that bound of patentability.
So what, if somebody were to come to you at the beginning of a startup, what advice would you be giving them?
Well, one of the first things I would tell them is to do a patentability search. Because like I mentioned earlier, this is a very saturated market. A lot of high tech is being invented all the time. A lot of it is trying to be patented. And you have to make sure that your invention is, I guess, more so inventive rather than novel. And the difference is whether there's something that's novelty is whether it's something identical exists out there, has been published, has been made aware to the general public. And inventive is whether someone that's a professional in the high tech field, in the software field, let's say artificial intelligence field, machine learning, based on what has already been published, he'd be able to combine different technical features that have been published in different locations, logically combine them, obviously combine them, and achieve this new invention without too much effort.
So you mentioned 2 terms, novelty and
inventiveness.
So what's the difference between them? Even though you just did define them, but can you make it clearer?
Yeah, sure. Novelty is when something is identical to your invention, what's been published, what exists in the world.
So what's novel about it?
So what's novel about it is that that's the point, is that you want it to be novel means it doesn't already exist.
Ah, okay.
Exactly.
So novelty means that you're not making something that already exists.
Right. You're saying nothing like this exists in the world. Now, usually that's can be a pretty easy thing to do because by just adding one simple feature or taking away a feature, you can make something new.
Right.
Okay. The question then comes to what is known as, in many places in the world, as inventiveness, or in the United States, it's called obviousness, meaning something that one skilled in the art in a specific technical field would be able to take what is known in that field, even if it's not found in one specific place, like in one specific invention, combine it with something that he found elsewhere in that technical field or somewhere else, and combine them in a manner that in his brain makes sense.
Mm-hmm.
So it's a subjective test, but it's one that if the delta is small enough...
What do you mean delta?
The difference between your invention and what's known in the art, if that's small enough, it means it's too obvious, meaning it doesn't pass muster to be patentable. If that delta is bigger, then there's a higher likelihood that it's patentable.
Mm-hmm.
Unfortunately, this is a more subjective test as well. It's kind of to describe it. And
so can you think of an example of some invention that took two parts, put them together, and was patentable? Or an example? I'll tell you what I was thinking of. Okay. Somebody has like a little go-kart, and they attach a solar panel to it.
Yeah.
So you're taking two separate technologies, you're putting them together, and you say, now I have a solar go-kart.
Right. So
would that be patentable?
Maybe. Again, that's why I say you do a patentability search, and you see what exists out there. And then you kind of give a indication whether or not this is something that is likely to be inventive, whether that combination would be something that an examiner, when looking at your patent application, would come and say, oh, this is obvious because I found this and this and this publication and this publication. Let's say an article or a previously published patent. Combine them and say, well, this is the result that makes sense and clearly shows your invention.
Something new.
Something new. Or it doesn't.
Mm-hmm. So we had completely new, like never existed before. And then we have taking different parts from things that exist and combining them to make something new.
Which, if you think about it, that's most inventions today. Nobody really reinvents the wheel anymore.
Mm-hmm. Although I'm sure people do try to reinvent
they try
the wheel.
To. Yeah.
I read something about an airless wheel.
Yeah.
So I'm sure people are still trying. But the idea meaning that, well, wasn't there a quote from like 1890 or something?
Right, that everything under the sun has already been patented.
So just close down the patent office.
Exactly. And still people are filing more patents now than they ever have been.
What do you see that's unique in Israel regarding patents than in other places in the world?
What's unique is that people here have a drive for innovation to create. You see a lot of great inventions and great ideas that come out of here. I think it's from the creation of the state of Israel that we've had to rely on ourselves and on innovation. I took my kids over Pesach to the tank museum in Latun. And one of the most amazing things you see there is that although most of the tanks that we received up until the time we invented the Merkava and the more modern tanks, they're all bought either from the United States, the patents, or from the French or the British. But each and every one of them had been modified by the army. They changed something and improved it. And I think that mindset, and including that time that a lot of people spend in the military here, that encourages innovation in ways in problem solving, they take that with them later on to their places of work and to the university, and that ability of teamwork and coming up with solutions and ways to advance things that already exist, or think of solutions to problems that maybe other people haven't thought about, the Jewish brain, as the way it works. So I think that really pushes the market here and the high tech. I think in all fields of technology, not just in high tech and medicine, you see it as well. You see it in the pharma industry. Tev is one of the biggest companies in the world. They started here. You know, I've edited all the episodes of this podcast. I know. It's like 30-something episodes. So I've learned a lot. So I'm sure you have, yeah. And one of the things that people talk about is networking. And how if I want to talk with the CEO of the biggest company, they'll meet with me. They'll meet with like a little know-nothing. Even if it's just for 15 minutes. Right. The people are willing to give their time here. I think that's also because at the end of the day, we're all family to a degree. You know, everybody plays that game of six degrees of separation. And when you meet a new Jewish person. Jewish geography. Exactly. So we all feel related to a certain degree. We all have a common goal to it also. So I think that helps everybody feel like they're playing on the same level. Getting back to patents specifically. Right.
What's a colossal failure that you've seen? Like somebody who came and in the beginning it seemed like this was going to work out and it didn't work out. And why didn't it work out?
It goes back to my point about the patentability search. That people come in sometimes and they're so sure that they invented something that does not exist because they did a Google search, they looked it up, but Google doesn't show you what exists as far as patent applications that have been filed and in other places around the world as well, because that counts for patentability. And they insist going through the motions of filing a patent application and going into examination when they're very headstrong about it without the search.
Got it.
And then we reach the point where that first office action hits, and there's always that shock of like, wait, how is this possible that this exists? I didn't find it when I looked for it. Mm-hmm. And this person has just invested a lot of money.
But you tell them beforehand.
Well, we try to warn them and we try to encourage, again, very strongly, I try to encourage everybody I meet for the first time, especially when you take into account there's people that usually a startup is a person or several people taking money out of their own pocket to start this new endeavor. They're taking a very big risk and you don't want them to spend their money in the wrong place at the wrong time.
Right.
And that patentability search can definitely help you, first of all, avoid spending all that money later on that's going to come back and fall flat on your face. Mm-hmm. As well as it's going to maybe give you a better understanding of what's out there and maybe help you realize that you have solutions for problems that you didn't even realize that exist. And that can help you improve your current invention and push it even further.
Explain that.
Okay.
Because we went from a patentability search to realizing that it might lead to a better idea.
Yeah, because a patentability search, one of the things that it does is it creates a map. It shows you also landmines that you're likely to fall on your path because you know what you invented.
Right.
You know how it works. You think you know what's out there in the market. And I say you think you know because, again, most people don't look at patents or patent applications that have been published prior to the day they file a patent application. So they don't know what's been filed, and not everything that's been a patent application has been filed for has reached the market. And even patents that have been registered don't always make it to market for various reasons. The company doesn't have the funds. They didn't find funding. They didn't have support. Something in the production didn't work out. So
they have the patent, but you won't find anything out there.
They have a patent, or it went abandoned.
Got it.
Or something along the way happened. Partners fought. They dismantled the company. Nobody wanted to keep pursuing it. The market shifted. That happens a lot.
Sure. Look at Blockbuster Video. I always think about that. It's amazing.
Netflix were thinking ahead and Blockbuster were
still in the past.
Yeah.
Yeah.
And when they tried to catch up, it was too late. Same thing with BlackBerry. They were back in the 2000s. Everybody had a BlackBerry. Movie. Yeah. Everybody had a BlackBerry. And then iPhone came out. BlackBerry were not ready for it.
They were convinced people wanted to touch the keyboard.
Yeah. But that's why nowadays iPhones and other phones, they kind of vibrate and click a little bit because it gives people that sensation of actual keys. Anyway, back to what I was saying. Mm-hmm. When you map it out and you see what's actually been out there that in your technical field, now you know what already exists there, what is likely to be close to your technology that makes you less patentable, and maybe what they didn't realize that they were doing wrong or could have done better, that now you can implement and add on to your invention and improve it and even give it maybe a bigger boost and also at the same time make it more patentable.
So in a sense, when you're doing a patent search, a proper patent search, not just a search on Google, you're seeing the whole field in a way that you couldn't have seen before. And knowing your own technology and knowing what's out there might give you a better idea of what you really need to invent to serve the market.
Correct. Yeah.
Whereas before that, you would have just been focused on your idea, not realizing what really needs to be solved that hasn't been solved yet.
That's part of it, yeah.
How about a great success? Can you think of something that was just like everything checked the boxes and worked out perfectly? Or does that not happen?
Well, actually, I do have one client. She was very innovative and she didn't do a patent search. And she didn't need to because she found the technology that was advanced enough in her field, which is image processing. Mm-hmm. And she got the patents almost immediately because there was nobody else like her in that field. So here she's kind of the exception to the rule that I said earlier that you should do a patentability search.
So that was a fluke in a sense.
Yeah, in a sense. But usually the successes are people that they do the search. Then once they get the search, they see how they can kind of slightly modify or improve what they have. Or we see that there's nothing to worry about. And then we proceed to draft a patent application and proceed. And usually it's slow and steady wins the race and not...
Well, how long does that take?
Well, a search is usually between a week to 2 weeks. We generally do it here in the firm. After 2 weeks, we reconvene. We prepare a report for the client and we send it off to them. They look it over. Usually there'll be a follow-up telephone conversation or a meeting, Zoom, in person. We'll discuss it. We'll see how they feel about the search report. We'll tell them what we think. Even though we write it down, it's also good to discuss things. And then after that, usually we'll draft a patent application, depending on how much the client needs to go back to the drawing board or not. But if they don't, then we'll proceed to a patent application. That usually takes between a month to 2 months to draft the application, making sure that everything's good, I's are dotted, T's are crossed. We file it and then starts the process of, depending on how they file it, it can take between a couple of years to several years until they get a patent.
Wow.
But by that point, once they file something, they're already usually able to get into the market and start doing
With some level of protection? With
some level of protection in the sense that nothing that's going to be filed afterwards is going to prevent them from filing a patent, because they've gotten their priority date, which is the date that you file a patent application, and nothing that's published after that date or filed as a patent application after that date can be used to claim that you don't deserve a patent.
So it's a line in a sense. Everybody takes a number.
Exactly.
And until your number's called, you're not going to get a patent.
Correct.
Okay.
And it's a constructive notice for those who may be potential competitors to say, look, this is filed, this is pending now, but there's a good chance that in the future, this is going to be patent. In which case, you will be infringing and you will have to stop doing what you do or we'll come after you.
I'm assuming there are some businesses that just take that period of time and put out a similar product until they have to stop it, and they just keep doing that again and again?
There's definite risk to that, is that you're investing money and starting... First of all, you don't know when the patent's going to drop, if it's going to drop. Let's say. So you're taking this risk that you're going to invest in this product that you're going to start manufacturing, producing, marketing, and selling. And now all of a sudden you're going to have a drop dead deadline that you're going to have to stop, or you're going to risk continuing and then being sued for infringement. Now, for the person who filed the patent, you're kind of doing them a service because you're creating market demand that at some point probably not going to be able to supply, because now you have a patent to deal with. Now the person that owns the patent, he's going to be able to fill in that bubble, that demand that you created.
Got it.
So you have to take into consideration, do you want to invest all that money and all that effort just so somebody else is going to benefit from it?
At what point should people try to file for a patent?
Usually the answer we would like to say as patent attorneys is as soon as possible. But realistically, it really depends on how far into development you are, how certain this is your final product, how much money you have, how you're going to be able to invest it, and what your business goals are, really. Usually patents are a necessary evil for investors.
I was just going to ask that.
Because investors are not going to want to invest in your company unless they know that their investment is protected. So if you go to someone who's going to be a potential investor, you usually want to have at least that patent pending so that they feel that you've done your due diligence in protecting yourself and ensuring that you have that long-standing market placement by filing the patent application. Right. So usually I'd say maybe not the first thing you do, but it definitely should be on your top 5 list.
Early on. You'll have to do that before investors are going to give you significant money. Is that what you're saying?
A significant amount, yes.
Like the beginning, you get a seed investment. They won't need a patent.
Usually here in Israel, you have certain public offices that will help a lot of young startups with that initial seed money. But once you start talking about getting more than that and getting past those relatives that really want to help you out and see you succeed, you're going to have to protect your assets and your IP by filing patent applications, or at least one. I guess one other thing is I'll mention is long-standing relevance. One thing that, because like we mentioned earlier. What is
long-standing relevance?
So I'm going to now explain.
Okay.
Because high-tech and this field is very fast advancing, especially as we see, let's say, with AI and machine learning, deep learning, you kind of always want to have that next poker card in your pocket.
Right.
You want to know what your next step is as well. You don't want to just be like, okay, this is all I'm inventing. You don't want to be Kodak or BlackBerry. You don't want to be like, okay, this is my technology. This is what I'm sticking with. And I'm putting all my eggs in this proverbial basket. I want to be able to say, okay, this is my stage A. My stage B is probably going to be this. Stage C is going to be this.
Mm-hmm.
Now, I want to be able to change my plans based on how things are going, but always look where you're going, not just where you are.
Look far ahead, you're saying.
It's good to look far ahead, yeah.
Mm-hmm. Even though the far ahead will also change.
Correct, but you want to have your hand on the pulse. You want to be able to kind of do as best as you can with predicting where the market's going to go and have your innovation also you want to be the driving force of the innovative market. Mm-hmm. You don't want the market to push you. So you should have that where do I want to take this?
Mm-hmm. Thank you very much for your time.
Thanks for having me.
And for the information. And I hope the listeners get a lot out of this episode.
I hope so too.
And make sure to contact us at jmbdavis.com. We can get you in touch with Eviatar, where he can help you with your patent.
See you there.
That was Eviatar Aron of JMB Davis Ben-David. We hope you enjoyed this episode. There are many more to come. Do you have a great innovation or startup idea? We'd love to hear from you. You can reach out to us by going to our website, jmbdavis.com. And if you go to jmbdavis.com/startup, you'll see we have a special site specifically made for startups to help startups protect their innovations. Please be in touch with us and find out how we can help you. Thank you for listening, and we look forward to bringing you the next episode.